Yes, Mr Dunham.
Obliged, my lady. In trying to tease all of this out, in my submission, what one sees as one looks at the explanation given by Professor Stanton, as one looks at the cases of Haig, Pickering, both quoted by Professor Stanton, Morrison, what one sees is not really a radical departure from what was said in Cutler, but an expansion of that, because the court made it quite clear in Cutler that the central question was not just, is there an intention to protect a particular part of society, but rather, is there an intention to afford a civil right of action to underpin that protection? And we see that, for example, in the speech of Lord Normand, MS page 330. Top of page MS 330, original page 413. If it had been the intention of the legislature to confer a right of action on the members of the several groups of bookmakers, one for each racing track, it would not have omitted all reference to the groups and to their right as associated with a particular track. And likewise, if one turns 2 pages on...
Well, the next paragraph is a very important one, isn't it? The matter he wants to deal with concerns penalties provided. If no penalty, may be presumed that those who have an interest to enforce have a right of action. If there is a penalty, the right to a civil action must be established by a consideration of the scope and purpose of the statute as a whole.
Yes.
The inference that there is a concurrent right of civil action is easily drawn when the predominant purpose is manifestly the protection of a class of workmen by imposing on their employers the duty of taking special measures. He's making the point that if Parliament, similar to Lord Dew Park's point, that if Parliament chooses to remain silent, then it can expect the courts to work on certain expectations.
Yes, but again, what we come to is the important intention is the intention to confer a right of action. And so again, as we turn on in Lord Normand, page 415...
Well, no, sorry, are we right on that? Because he says, he quotes Black then, the principle explained by Lord Cairns solves the question. We consider the scope and purpose of the statute, and in particular for whose benefit it's intended. When a duty of that kind is imposed for the benefit of particular persons, there arises a correlative right in those persons who may be injured by its contravention. So that's how he's looking to divine Parliament's intention. For whose protection is this intended?
But there are 2 questions, because otherwise we're ignoring what was said by Lord Johnston and Haig. There are 2 questions. Is it designed to protect, and is there an intention to enforce, or to allow the enforcement of that protection by way of civil right?
Now, do you get separate consideration of those 2 different points anywhere in Cutler?
So if we read on at 415, this is still Lord Normand. Duty of Section 11 is certainly not more important than some of these, and it is fair to infer that that particular duty was not intended to have the additional sanction of civil liability. Lastly, if civil proceedings at the instance of an individual bookmaker are competent, there is no provision that a judgment of the civil courts has been contravented may be cause for withholding and forfeit of a licence. And it may result that bookmakers would always resort to civil proceedings and would never initiate criminal proceedings because it's contrary to their interest. It is reasonably certain that that is not what the legislature intended. So yes, we have here a discussion about what is the intention of the legislature with regard to civil actionability. And the same is said, well, Lord Morton agrees, and we also have the same in Lord Reid. Page 417 of the original print, MS 334. About 5 lines in, I see no reason to infer from the Act read as a whole or from the circumstances founded on that the enjoyment of these facilities required or was intended to have any further protection than that afforded by the track occupier's liability to prosecution. if he failed to comply with the statutory provisions. And at page 417, Lord Reid, MS 334, this is now about 10 lines into that page. I find it extremely difficult to reconcile the nature of the provisions of this subsection with an intention to confer on individual bookmakers rights which each could enforce by civil action. If the legislature intended to create such rights, I would expect to find them capable of reasonably precise definition. So in my submission, Professor Stanton is right.
Well, you said you were going to refer to Lord Duparc. Do you intend to? If not...
I think your Lordship has already noted the passage I wanted to take from Lord Duparc, I think at 337. MS 337.
327.
327, your Lordship's
Yes,
quite right.
there's a relevant passage also on the following page, 328. Towards the third page, where he says that if Parliament, if it wasn't thought fit to break with tradition and state explicit in the Act whether an aggrieved bookmaker was to have a right of civil action,
Yes.
Parliament must be taken to have known that if it preferred to avoid the crudity of a blunt statement and leave its intention to be inferred by the courts, the general rule would prevail unless the scope and language of the Act established an exception. Can't be supposed the draftsman is blind to the principles which courts have laid down for their own guidance when it becomes necessary to fill in gaps.
Yes, and on what the intention that we're looking for, this is why it is ineluctably correct for Lord Johnsey to have said it's not just protection, it's protection plus an intention to create the cause of action. Now, I mean, in this regard, everyone sympathises with the difficulty in trying for the court to trying to tease out exactly what it does, and in that regard, I recall the comment from Mr. Justice Neuberger, as he then was, which is repeated in a different case, the Zemiak case, MS page 744, which would be, I think, the last tab in the authorities. Paragraph 29, in giving judgment, Mr. Justice Neuberger quoted an observation from Clark and Lindsell, which very much mirrored my own thoughts on listening to argument in the instant case. Unfortunately, most legislation fails to give any express guidance as to whether an action of damages is available for its breach, and then the courts have to decide what Parliament intended. Determining Parliament's intention when it's pointedly declined to express one is something of a haphazard process. The court looks to the construction of statute relying on a number of presumptions for guidance, but in practice there are so many conflicting presumptions with variable weightings, it can be extremely difficult to predict how the courts will respond to a particular statute. That is doubtless the case. That is what has given rise, no doubt, in the particular situation to so many different opinions. But what I say ultimately is that is clear in this case is that when one looks at the way the Act is framed, there are so many pointers away from personal liability that you just don't get there. And in that regard, I mean, bearing in mind the time, I think without reading it to the court, in my submission, the approach of the majority in this case, Lord Brodie at paragraph 10, MS page 66, and of Lord Malcolm at page MS 98, is one that should commend itself to the court, where they explain the modern law, which is trying to discern the parliamentary intention, civil action or no, and they then look at the various pointers. And we give the pointers away from civil actionability at section 4.3 to 4.10 of the written case. And most important of those are, this is pure economic loss. This is not building on any sort of liability that would have arisen between a director and an employee of the company before the 1969 Act. So it would be an entirely fresh type of action. Lord Malcolm in particular said that was a relevant consideration in my submission. He's right to do so. And in that regard, while parties don't put anything from Hansard before the court as being of particular help, The court will recall that in Richardson, the one reference in Hansard which is of some relevance here, this is at MS 644. In the case of Richardson itself, Lord Justice Russell, referring to Lord Pargeter in the committee stage of the bill in the House of Lords, is at letter E. May I say at the outset, there's nothing in this bill, so far as I'm concerned, or the sponsor in another place is concerned, to alter the common law regarding liability in the relationship between an employer and an employee. Well, if I am wrong in this case, then Lord Pargeter was wrong in what he said in that passage in Hansard. Because prior to the 1969 Act, there is simply no question that a director, let alone a company, could be sued for failure to put in place employer's liability insurance.
When he speaks about a sponsor, was this a private member's bill?
Yes.
It was, my lord, yes.
It was taken over by the government at rather a late stage, or at least
Yes.
they offered drafting assistance at quite a late stage.
Yes.
We haven't traced the drafting history of the bill, what it was like when it was first introduced and what it was like when it left Parliament. You probably have. Is there?
We, other than what is quoted in Richardson, we've found nothing of any assistance in the background material in Hansard and the like, I'm afraid to say.
Well, for the purposes of Pepper and Hart, I think we draw a distinction between what's actually said in the debates and the course that the drafting of a bill has taken.
Yes.
And we're much happier to look at the course that the drafting of a bill has taken, assuming that if Parliament amends the first draft, it's got a reason for doing so.
Yes. I mean, and to be fair to the judges in Richardson, they said, look, there's only so far one can take this. There's a real question about whether or not the Pepper and Hart circumstances are actually justified. But so I can't lay great stress on this, but what I can say is that in the House of Lords, Lord Pargeter said something without demurral, so far as Hansard reveals, which is, if I am wrong, patently wrong. Of the other relevant factors adopted by the majority...
So why is it wrong? There's nothing in this bill to alter the common law regarding liability in the relationship between an employer and employee.
Well, because prior to the 1969 Act, there could be no possible question of liability being prestable against an employer or, in particular, the director of a corporate employer for failing to put in place
It's linked
insurance.
with the argument.
Yes, I wonder if you're cross purposes. When you're saying that what he says is right,
Yes.
but if Mr. Smith were correct, what was said by the sponsor of the bill in the House of Lords apparently would have been wrong.
Absolutely. Absolutely. If I'm wrong, he's wrong. If Mr. Smith is right, he's wrong. That's what I'm saying. Of the other relevant factors that have been found material in both the Court of Appeal in Richardson and in the Inner House of the Court of Session, other ones that I would stress are the language of Section 5 is all criminal language. It's all about penalty. It's about guilt. It's about offence. There's no talk of duty, of obligation, of liability. And it would pierce the corporate veil with, as was noted in Richardson, pierce it with a vengeance. And crucially, it would do so in a situation where the statute simply does not impose a duty on a director at all. The delict complained of here, the tort in Richardson, is a breach of statutory duty. There's only one duty imposed by the 1969 Act, and that is by Section 1 on an employer.
No, that's really a separate point. It might be your first point.
Well, and that's why I said crucially. It's the most clamant one in my submission. And really what I'm doing is just trying to emphasise the various factors which I see point away from imposition
I mean,
of
can I
personal
just-
liability. The Lord,
And
yes.
it seems to me that is quite an important point. I mean, in a case like Monk and Warby, you start off with a provision which says there shall be a duty
Yes.
on anyone who permits someone to drive a car to make sure it's insured.
Yeah.
And then the question is, does that duty sound in civil damages? And one of the questions is whether subsection 2, which imposes a criminal penalty in a way, detracts from that.
Yes.
But here it's the other way around, isn't it? I mean, the duty is imposed on the company by section 1.
Yes.
A civil penalty is, I mean, a criminal penalty is imposed on the company by section 5.
Yes.
But we can have a debate about whether there's a civil liability on the company, but if there were, it would derive from section 1, not from section 5.
Absolutely.
I mean, am I right? I mean, has there any case where the section which sort of like this imposes a criminal penalty is in itself said to create a civil liability?
That is why when I made submissions earlier about the commonplace nature of the statutory mechanism, I said Westlaw Search reveals 984 instances of this used and 0 instances, other than the minority opinions in this sphere, of any court saying that means the director is personally liable.
So, I mean, your primary argument here is really the case never gets on the ground because there's no duty imposed on the director.
Absolutely.
End of story.
Absolutely. And that is what resonated with Lord Brodie and Lord Malcolm. The answer, it's most pithily stated by Lord Brodie in paragraph 23 of his judgment, that's MS page 75 in the appendix.
Which paragraph?
Paragraph 23, my lord, page MS 75. Lord Diplock's general rule applies where an act creates an obligation. A further point on which I would take issue with the dissent in Richardson is that I do not find in the Act an obligation imposed upon directors as opposed to employer companies. This is not a matter of subtle wording. As I read the statute, the obligation is simply not there. A director may be made criminally responsible for a breach of the company's obligation, but that is something different from the imposition of an obligation. That is, in my submission, axiomatic and plainly correct when one looks at the way the statute is drafted. And in my submission, this argument could begin and end with Section 1 and Section 5. Look how the parliamentary draftsman imposed these obligations and upon whom they imposed them. Civil liability does not get off the ground for that very reason.
I mean, can I just ask you, I put to your opponent the fact that your client is presumably exposed, potentially, to the company, if the company is unable to pay. But it may be able to take proceedings against your client for breach of duty, his duty as a director. But what is this litigation all about? Because on any view, he doesn't seem to have the money to meet any claims in any direction.
Well, the answer to that...
It's about costs.
No. The practical answer to your lordship's question is the fact
It's
that...
a test case or something?
No. The point needs to be decided.
Yes.
But the practical answer to your lordship's question is that if liability is established against the defender, then what the pursuer wants to do is to take that liability and use it to go after the broker. Because in effect then he will be able to say to the trustee in sequestration, I need an assignation of your claim against the broker. Broker, you have negligently advised here.
Why does he need to establish liability against you for that? I mean, he's a claimant against the company. He can presumably control the company by putting a liquidator in.
Well, indeed.
And he can take the action in the name of the company.
Indeed, and that is all a pointer away from the liability that is sought to be imposed by my learned friend.
Well, maybe. I'm just trying to understand what the litigation is about, because it's puzzling me.
Yes, well, the other point that arises from this very question is that the duties owed by the director to the company seem to have resonated with Lord Drummond-Young. And your lordship mentioned the passage in Lord Drummond-Young's opinion earlier, but it should be noted that the Lord Drummond-Young, with respect, somewhat overstates the position. This is this is the third of Lord Drummond-Young's factors.
Page.
This is in MS 85.
Thank you.
And it's actually, so he gives his 6 factors.
84, isn't it?
It is. The third factor is actually at MS 86. It's the one that paragraph
43, isn't it?
43, my lord. Yes. And it's just over the page. So it's MS 87.
Yeah.
A corporate employer can only act through its officers, and there is a duty on directors to ensure, so far as possible, that the company fulfils its statutory duties. Well, that in my submission overstates the position, because A, the duty is a duty owed to the company only under section 170 of the Companies Act, but B, that duty is not to ensure anything, but to act with reasonable skill, care and diligence. And that's section 174 of the Companies Act.
Yeah. Then he goes off on a bit of a tangent, doesn't he, in paragraph 44,
Yes.
where he says, obviously, if a director personally injures the employee, he's personally liable, or if he authorises or directs or procures the commission of the injury, then he's liable.
Yes.
Well, that's all true, but
So what?
so what?
Because what his lordship does there is to effectively equiparate procure or direct with consent, connivance or neglect. Now that is a false equiparation, because neglect could mean anything. This is the liability that the court would be imposing here would arise in any situation of simple inadvertence. It would not be, as his lordship seems to suggest, the same as when somebody goes out and commits an offence, an intentional wrongdoing, where someone goes out deliberately to frustrate the requirement to insure.
Well, that would be a conventional common law liability.
Precisely. And the same problem then infects his lordship's analysis when he says his 5th factor, this is at paragraph 46 of page 88, he says, in the 5th case, where a director has been responsible for the company's failure to obtain insurance, it's possible he ignored or deliberately disregarded the existence of the statutory duty. In that event, he's personally liable. So, well, in which case, so what's the need for a statutory liability? He's personally liable at common law anyway. And then he says, alternatively, the director, aware of the duty to obtain insurance, may have obtained proper professional advice from an insurance broker and acted on that advice. He'll have a right of recourse against the insurance broker for professional negligence, and that's the point made by my learned friend. Well, the difficulty there is there's a rather massive lacuna in that analysis. So on the one hand, he is the deliberate, malicious director. On the other hand, he is a director who's acted in good faith and has a negligent broker to go against. The rather large lacuna is a situation where either there's no broker involved at all, or the broker hasn't been negligent. So that analysis doesn't take the case anywhere. And the last factor put forward by Lord Drummond-Young is that, well, the argument is overly literal. In my submission, it's not overly literal. In my submission, the answer is given compellingly by Lord Brodie in the passage I took the court to earlier. The obligation simply isn't there. It's not a question of subtle wording. It just isn't there. The only 2 factors from Lord Drummond-Young I think we haven't looked at is that his first factor is protection of employees. Well, I think we've done that to death. That's not the be-all and the end-all. And secondly, his second point was, he said, I'm going to adopt a purpose of construction. Well, a purpose of construction is there to implement parliamentary intention, not to divine what parliamentary intention might be. One can't start with a purpose of construction until one knows what the parliamentary intention is. That would be to put the cart before the horse. My lady, my lords, this all leads me back to where I started. It's all about parliamentary intention. And in truth, it does begin and it does end with Section 1 and Section 5. The obligation isn't there. The director is not personally liable. This appeal should be refused. Unless there's anything arising, the court has my submission.
I think you've been asked all the questions that anybody wants to ask you. Thank you very much indeed, Mr.
Pleasure.
Dunlop. Mr. Pugh?
My lady, my lords, I have nothing to add to the merits in terms of questions. Thank you.
Thank you. Mr. Smith?
Lady, I wonder if I might give a short reply. It is correct to say I fully acknowledge that Professor Stanton is critical of loan rule and indicates that the law should be that something more is required. But the analysis is that loan rule is incomplete rather than wrong. And I could and do accept that that's a fair analysis. But what I say is, in this case, there is that something more. As I indicated before, the something more is the combination of the 1930 Act together with the 1969 Act and also the private relationship that exists between the employee and the employer. There's a very defined class. And in my submission, that's something important to bear in mind, together with the acceptance by my learned friend, that was the concession in Richardson, that the legislation is designed to give a measure of protection to employees. Now, there was some discussion about the parliamentary progress, and I must confess, in the first draft of the written case, my learned junior put something in that I took out. I will happily provide this in due course, but apparently during the passage of the 69 bill through the House of Lords, sponsor Lord Pargeter said, "The bill represents an endeavour to ensure that the employer will take all reasonable precautions to ensure that he is in a position to meet his liabilities. There have been cases where, for various reasons, such liabilities have not been met, and employees have suffered very often by reasons of ignorance on the part of the employer. We will make sure that that is provided to the court." There's a very clear statement of intent there in my submission, which is important. The second point that I wish to make is this, that my learned friend places much emphasis on the lack of litigation arising from similar provisions to the present one. Now, I'm sure that the search of Westlaw that I carried out must be different words to my learned friends. I searched for the particular words and came up with two hits. One is this legislation, and the other is the 1934 Workmen's Compensation Coal Mines Act, which is in very similar terms to the 69 Act. And of course, this case shouldn't be determined on the basis of the number of Westlaw hits that either party can come up with. But what the court has to be careful about is that many of the similar provisions in legislation are purely regulatory. By way of example, and I haven't checked, but I think I'm right in saying the Companies Act requires that a company submits annual returns. If there's a failure to do so, a director will incur a criminal liability for failing to do so. Now, one cannot envisage any circumstances under which a private individual would sue that director, or probably not the company itself, for failure to comply with that legislation. So the lack of litigation arising from this wording is unsurprising. We're dealing with a very specific and almost unique situation that's before this court. I remind the court something I said earlier, that even though there's a criminal sanction, the observations and the MS numbers from two cases are 236 and 526, where it's made clear that the presence of a criminal sanction is not a complete answer to the question, which is, of course, one entirely of statutory interpretation. Some discussion took place regarding the difference between the Monk and Warby case and the way it's put, that it's unlawful to do something as opposed to deeming provision. There are different dynamics, of course, in road traffic legislation, because one can readily find out who the owner of a motor vehicle is, as to where the obligation to insure lies, with a company to try and convert that into who's responsible for taking out the insurance. It's different, but I do maintain the position that the net effect doesn't make any difference regarding the two alternatives in the wording.
Well, the owner of a motor vehicle could be a company.
It could be, I accept that. But still,
rather frequently is.
It becomes rather circular then. My learned friend did place a lot of emphasis on the question of piercing the veil. But in my submission, that's something that if the legislation says what it says, then it does what it does. the court shouldn't have in mind that essentially common law principle from the Salomon case to instruct how the legislation is interpreted, because as been discussed, particularly Lord de Park points out that Parliament has to be presumed to legislate against the background of what the common law principles are. And in my respectful submission, it's not in any sense piercing the veil any more than the imposition of the criminal sanction could be said to be piercing the veil and wrong, albeit I accept that that is specifically and undoubtedly provided for in the legislation. I wonder if I might deal with the Wong case, because my submission is different. My learned friend places great emphasis on Wong, and of course it's a court which ought to, the composition ought to attract considerable respect, and it's in tab 21, it commences at 669. Now what that case was about was the employer company had failed to put money into a pension fund, and the employee considered that he had a right to take proceedings against the officers of the company for the failure to put the money in. But, and crucially in that case, the employee had the right to sue the company for the funds in order that it could be put into the fund. And that was the critical difference. And we can see on page 673 the important provisions, reading from about a third of the way down the page. Section 16 deals with civil proceedings. Here, contributions, including surcharges payable, can be recovered as a debt by the board. The contributions are payable by the employer and are accordingly recoverable as a debt from the employer. It does not seem to this court that it is possible to say that by necessary extension or implication, directors are also liable if liabilities were intended to be extended to directors for the company's debts. There would have been specific provision dealing with directors, as there was in regard to liability for criminal offences. And then there's the reference to loan roll. And just reading the last couple of lines in the next paragraph, the two exceptions referred to by Lord Diplock do not apply. The objection here was imposed on the company and can be enforced as prescribed. It was not imposed on the directors. And the next section, Richardson against Pitt Stanley, again reading from the last two lines in that paragraph. Here it is different. There is an express civil liability on the company and none expressly on the directors. So if one applies the expressio unius rule, then that's the way they approached it. There is a way of recovering it. So in my submission, the Wong case is really of no assistance whatsoever to my learned friend's argument. The next point I wish to mention is this, that my learned friend places great emphasis on the observations by Lord Roger in the Morrison case. But in my submission, it's plain from reading what Lord Roger said that it was a very limited criticism, as it were, of what Lord Justice Atkin had said. And it's in the desire to try and tease out the question of whether the division, the inner house in Morrison's, had got it wrong when they said, we need to find a class, but that class can be the general public. That was the limit of the criticism by Lord Roger of the division. And accordingly, any criticism of reliance on Lord Justice Atkin is similarly limited. And in my respectful submission, we have to bear in mind that there are two aspects to the analysis of statutory interpretation, and I touched on these at the outset. There's first of all, is there a protected class? And secondly, does it apply to all of Her Majesty's subjects? And I'm dealing with the protected class aspect of this, which was not an issue in Morrison Sports. So in my respectful submission, any weight that can be placed in Lord Roger's observations are limited. So in summary, my lady, my position is this, that I'm sure this court has, in some respects, a desire to avoid upsetting the statutory interpretation apple cart that seems to have been doing quite nicely so far in this particular case. But I say this case is virtually unique, and it requires a different approach to the generality of statutory interpretation. It's unique because there's a very defined class, and it's clearly intended to protect the individuals. And accordingly, any decision in favour of the pursuer in this case would not affect the generality of the long line of authority on statutory interpretation that is difficult, but I submit not only established but in favour of the pursuer. So unless I can assist further, these are my submissions.
No, thank you very much indeed, Mr. Smith. We're very grateful to all concerned, because we know that your juniors have also worked very hard on this case, and no doubt those sitting behind you as well, for everything that you have put in front of us in this very intriguing case. We shall, of course, take time to consider what our answer will be and let you know in the usual way. Court is now adjourned.